Hello and good afternoon. Thank you for being here with me this beautiful Sunday, the 8th of November 2020. My name is Joyce Daniels. I'm honored to have you here with me and the rest of the team. This is the third Sunday in a series where we're discussing the Nigerian Constitution, understanding the rights of the Nigerian citizen. So, with recent occurrences in Nigeria, there have been all sorts of questions about what to do, what's the way forward. We're seeing things in governance and amongst the citizenry, and we are all wondering what to do next. So for me, I felt, you know what? Let's even understand what the laws that guide us as a people are, or should I say, as a people. And what is that law called? It is called the Nigerian Constitution. So I downloaded a copy. Definitely not the first time I had downloaded one, but this was the first time I was going to really study it. But I couldn't study alone, so I invited a team of professionals from Primera Africa Legal, lawyers of sound mind to come on the show with us or on this program with us, Talk with Joyce, and discuss, dissect, and help us understand the Nigerian Constitution. We've studied the preamble, chapters 1, 2, 3, and part of chapter 4 last week, where chapter 4 discusses the rights of the citizen, fundamental rights of the citizen, and we stopped, let's see, we stopped at one of the sections. Today we'll continue from chapter 4 and still talk about the fundamental rights of the Nigerian citizens. We've seen a number of inconsistencies, a number of errors and flaws, but don't worry, after the last discourse next week, which is part 4, we will have a session where we'll begin to highlight some of the challenges we've seen with the Constitution and what we can do as a people, or should I say as a people, to improve our situation. Are we looking for an adjustment, an amendment, or a rewriting of the Constitution? All those will be covered between now and the end, the last Sunday, which is Sunday the 29th of November. Thank you all for joining us, joining me here today. Some people joining live on Facebook or on YouTube, or if you're watching the replay, thank you for being here. Allow me bring up to join me my team. These wonderful men and beautiful women who have been on this journey with me from Primera Africa Legal. Let me introduce to you Nonso. His face is directly below mine. Nonso, please wave to everyone. And right next to him is Maria Yunusa. Thank you for joining us, Maria. And right next to me is Sarah. Everyone is used to us right now. So you all can just unmute yourselves for a moment and say hi. And then I will hand over to Maria to start off the discussion.
Hi, everybody.
Hi, everyone.
Hi.
Welcome to Black.
All right.
Welcome.
Thank you. Thank you all. Thank you so much. I am privileged. I am honored. And I don't take your Sunday afternoon for granted. Not just your being here, but your commitment to this. Thank you. So, Maria, today's discussion will proceed to wrap up chapter 4, the section, subsection, and then we'll proceed with what we have in chapter 5 and 6, and let's see what we do with chapter 7. Okay? Sarah, Nonso, myself will go backstage and we'll leave Maria. Thank you, sir.
All right. Good afternoon, everybody. Thank you for joining us again on this our journey of discussing the Nigerian Constitution. Last week, we started a discussion on the fundamental rights. That's the chapter 4 of the Constitution. And today we will try and continue from there, and then we'll look at some other chapters if possible. Now, we stopped at section 38. That's the right to freedom of thought, conscience, and religion. And today we will start from section 39, right to freedom of expression and right to peaceful assembly and association, which is 40, section 40. Now, while discussing the chapter 39, I want to make much of emphasis on what we recently faced as a nation. As we are all aware, one of the major issue or a major challenge that faced us, or that we have been facing in recent weeks, is the issue of the End SARS or the End Police Brutality movement or protest. Now, as citizens, the Constitution guaranteed us the right to freedom of expression and peaceful assembly. Now, under this right, the Nigerian citizens are guaranteed the right to assemble and peacefully demonstrate against any action or any policy or program or any decision or action of government or its institution that are perceived to be against the citizen, or that are perceived to be against their welfare, or that are perceived to violate the rights of Nigerians. That's what the Constitution guaranteed us under Section 39. Now, it is expected that the citizens should exercise this right or this right to peaceful assembly without any form of hindrance or restriction and exposure that may be associated with public gathering. An attempt is made to stop or deny people their right to peacefully assemble and demonstrate against any action or inaction or policy of government. And it is considered that on the account of the health risks or the exposure that may be associated with such gathering, an attempt is made to deny the citizens the right to peaceful assemble and demonstrate. That will or may not stand in a court of law if that attempt to restrain or stop the citizen from exercising that right is made by people in authority relying on issues that will have to do with health risk. That will not be accepted, or that will not be entertained, or that will not be allowed by the courts, right? And my reason is simple. The Constitution anticipates that such things may happen, right? There may be some sort of need or some sort of need to a kind of regulate how people demonstrate or how people exercise this right. Now, the solution to such thing is for the state authority to insist that people should observe whatever protocol or rules and regulations that are put in place for COVID, basically. So it's to insist that whoever is exercising that right of demonstration, of peaceful assembly, of association, should observe whatever regulation, whatever law, whatever guidelines that is issued by the state authority in exercise of that right to peaceful assembly, right? And if in the course of exercise of the right, there is a violation of the protocol or guideline or rules that is set by the state authority, like that's the COVID guideline, then such violation becomes an offense in law. And the solution to it becomes to maybe try people in court of law, and if they are found to have violated those laws or such guidelines, they will now be punished in accordance with the requirement of the law. So the solution is not to deny people the right to peacefully assemble and associate and demonstrate, but rather the solution is to insist that such laws or regulations should be followed and observed in the exercise of the right. And if there is a violation of those laws and regulations, then the violators should be tried in the court of law. And if they are indeed found to have violated the rules, they should be sentenced and punished in accordance with the law. I will give you an example with what happened sometimes in 2014, I think, yes, 2014, during the Bring Back Our Girls campaign, when an attempt is made by the state authority to restrain or restrict citizens from exercising the right guaranteed them by the Constitution, and those people that wanted to exercise the right went to court, right? And what the state authority relied on is a law that is called Public Order Act, that provide that before a citizen should exercise the right, that is guaranteed by him or that is guaranteed to him by the Constitution, such a citizen should obtain a permit from the state governor in the state where the demonstration or where the peaceful assembly is to take place. Now, the court now declared that law, the Public Order Act, to be an attempt to achieve an unconstitutional means through the Constitution, right? Joyce, are you with me? Can anybody hear me?
Yes, we're right here. We can hear you, Maria.
All right, right. So that was the decision of the court. The court declared that law to be unconstitutional because it cannot, by way, or you cannot, by way of another law, deny the citizen what is guaranteed to them by the Constitution. So that was the decision of the court in that matter. And there is also another decision of ANPP against the Inspector General of Police. The decision I was referring to in 2014 is a case of Hadiza Bala against the Commissioner of Police of the FCT. So that is that with respect to right to exercise peaceful assembly. Now, another thing that we need to look at with respect to that is the limitations or the limit or to the right. And this is provided for by section 45 of the Constitution. And we will discuss section 45 of the Constitution subsequently. But just to state that if in the interest of public health, public safety, or public morality, it is discovered that the exercise of rights conferred on a citizen by the Constitution to peacefully demonstrate and assemble can lead to any form of violation of right of others, or can lead to any form of public health risk and all sorts of things like that anticipated by section 45, then such a right guaranteed to you by section 31 will be restricted or will be curtailed. Right. Now, this takes us to another discussion again. Now, if because of the anticipated issues that has to do with defense of the issue that has to do with public safety, public order, or public morality, or even public health, or for the purpose of protecting the right and freedom of others, it is anticipated or it is discovered that there is need to restrict and curtail the right of a citizen to peacefully demonstrate. What happened? Now, that is another responsibility placed on the state authority by the Constitution again. Now, the state has the responsibility or the duty to ensure the protection of life and property of every citizen, of every Nigerian. So if in the exercise of a citizen's right guaranteed by section 29, there is a likelihood of breaching the right of another citizen, there is a likelihood of issues of life and properties of citizens being put to jeopardy, then the state has the authority, or the state authority has a duty to ensure that that is prevented and that does not happen, so as to maintain law and order in a society, right? So the whole analysis around, or the whole discussion around section 39 is you have a right as a citizen to peacefully demonstrate or to peacefully assemble and demonstrate against any action or inaction or any decision or policy of government or its authorities. However, such a right has limitation as provided by section 45. Again, if because of the violation anticipated, or because of the items contemplated under section 45, there is likelihood of the properties and life of other citizens being put to jeopardy or become really at risk, then the state has a duty to ensure that, or has a duty to protect the life and property of all properties of other citizens. So that's that with respect to that that particular provision. I think I will leave it for questions, because I anticipate that there should be many questions, or there should be questions around that area for us to elaborate the conversation.
There is now, already a question about explaining to the, giving more explanation to the public order. You've been frozen on my screen for a while, so please let me just take you out of the studio for a second and bring you right back in. Hopefully it should have unfrozen. Or is it frozen only on my screen?
No, it's frozen.
Okay. Maria, please just refresh your device. I will bring Nonso. Okay, it's fine. You see, it has unfrozen. It's okay now. So let's go backstage. Please respond to Lucia, who says, "Can you give more explanation to the public order right?" Please respond to that, and then you might proceed. Thank you. I'm going backstage.
Okay. The Public Order Act is a law that is passed by the National Assembly that make a provision or mandate that every citizen that is to exercise the right to protest or that you exercise the right conferred by Section 39 should, as a matter of law, right, obtain a police permit, right? And that police permit is conferred, or that permit is conferred on the governor to issue. Now, before you can exercise any form of protest or any form of peaceful assembly, you must obtain what is called a police permit, which is a kind of approval that is given by a governor of a state for you to exercise that particular right in the state. Now, there is a decision that went to court. That's the case of IGP against ANPP with respect to that. And the people are now questioning whether, in view of the right guaranteed to us by Section 39, we can now not exercise that right unless and until we are given such a permit or approval. Because that law seeks to restrain or seeks to restrict our exercise of the rights guaranteed by Section 39. Now, let me read to you the decision of the court. The constitutional power given to legislature to make law cannot be used by way of a condition to attain unconstitutional result. The powers given to the governor of a state to issue permit under the Public Order Act cannot be used to attain an unconstitutional result of depriving the right of citizens of speech and freedom of assembly. That was the decision of the court. So the decision is to the effect that you cannot use a law to achieve an unconstitutional means. It is the constitution that guarantees the citizen the right to freedom of assembly and peaceful protest. If you are, there is a sort of fear, or there is a sort of the feeling that there may be some sort of arrest, there may be breach of law and order in the course of exercise of the right, the law contemplates that, and it provides that when there is such breach or violation, is to subject such violators to the same law to ensure that they are tried in a court of law and convicted, not to restrain or restrict or deny them the right guaranteed to them by the Constitution. I don't know if that's clear.
For me, it's clear for now. We'll go on. As questions come, we'll note the questions and ask more later. Let's proceed. Thank you.
All right. Okay. All right. So let us look at the right to freedom of speech that is guaranteed to us by Section 39 or by Section 40 of the Constitution. Right. Now, the Constitution guaranteed us the right to peaceful assembly and association and the right to freedom of expression and the press. That's freedom of expression and the press. Now, the freedom of speech and the press freedom that has become really a necessity in every society world over. And this is because it provides a platform or an avenue for positive criticism and reliable and intelligent reporting. And it also affords every citizen, whether in a democratic nation or not, an opportunity or a platform or a forum where issues of public interest and views are open to discussions and consideration and debate generally. Now, we find a situation where politicians and public office holders generally, it's not only in Nigeria, worldwide, in every democratic nation, also have great interest on how this freedom is exercised by the citizen, particularly on how organized media covers their behavior, that's the behaviors of people in occupation of public office. This is because they depend on the media to provide them information they need about the people and the society, and through this, the state or the government can be informed about what people of the country are doing, what they are thinking, and indeed what they need as a people, right? So it's an avenue for the people in authority, for people in occupation of public office to get to know what they need as a people. Because remember, in our last conversation, when we were discussing about fundamental objectives and the directive principles of state policy, we did say one of the reasons why that particular chapter, that's chapter 2 of the Constitution, is not enforceable is because it's an issue of policy and planning. And government need to plan and have policy on what is the basic need or what is the need of a particular citizen for it to have a priority over other needs. Now, the only way a government, or the only way the people in public office or can know what is the priority in hierarchy of needs of the citizen under the chapter is through information. And one of the avenues through which they access such information or they get to know about the needs of the citizen is through the media, is through the right guaranteed to us by the Constitution of freedom of expression, right? So whenever people are well informed, they can be trusted with their own government, as well as a kind of informed citizens could govern itself and secure the liberty of other individuals. That's something that is really very beautiful that we should all aspire to participate in as citizens, right? Now, for us to achieve a promise or the desire of a hyper-modern nation, that's a nation that looks toward a better future, they are a nation that aspire to do things in accordance with the modern way of living and the modern way of doing things. This right of freedom of expression, it is really a necessity and a desirable right that the citizen should be allowed to exercise. That's something that is not arguable. Everybody should agree with that, I believe, right? Now, there are some sort of distrust between people in authority, that's occupant of public office, and the citizenry on the exercise of this right. Maybe I will leave it for the later part of the discussion. But for now, let us look at maybe the limitations that are placed by the Constitution on the exercise of that right. Now, by the provision of Section 39 sub 3, that's the same Section 39 sub 3, the right to freedom of expression could be restricted by a law that is reasonably justifiable in a democratic society. Right. Now, if there is a law that is passed by the lawmakers that restricts the right to freedom of expression, and that law is deemed to or is presumed to be reasonably justifiable in a democratic society, then that exercise can be limited or restricted because of that law that is passed by the lawmakers. Now, the question will now be, what is reasonably justifiable? Now, this is a question for the court to determine, and it is based on the common man test that is being used by the court to determine whether, in the opinion of a common man or the ordinary man in the street, is that law reasonably justifiable for it to be invoked to restrict or to restrain the citizen from exercising their right to freedom of expression. So that's one area where it can be restricted. Or for the purpose of preventing the disclosure of information received in confidence, or for the purpose of maintaining the authority and independence of the court. Right? So we all know that since there is a kind of right that is conferred on the state or on judicial officers with respect to their actions and inaction in the course of their duty. So this is one of the areas where such rights were given to them, or where such protection were given to them. And also by section 45, I earlier mentioned that we will discuss section 45 subsequently, right? So one of the Constitution, the right could be restricted or curtailed by any law that is reasonably justifiable, again, in the interest of defense, that's one, public safety, that's two, public order, or public morality, or even public health, or for the purpose of protecting the rights and freedom of other persons. So I have made a lot of analysis and explanation while discussing such restriction under the freedom of assembly. I think I will leave it at that. Now, let me mention some sort of debate that has been going on recently with respect to this particular right that is guaranteed to us. We may all be aware of the current discussion on the need or on the desire of some representatives of the state authority to have the media space, particularly the social media space, regulated. And their reasons are due to issues that will have to do with fake news and maybe hate speeches, right? Now, this is really a very interesting discussion that maybe we need to follow as a citizen to understand what is the viewpoint of those that are from the school of thought that think, yes, there is need, it is necessary to regulate that space. And what is the viewpoint and what are the reasons of those who think that there is no need for that space to be regulated? Right. Maybe let me start with those who think there is no need for it to be regulated. There is a feeling that in Nigeria today, there are more than enough laws that regulate the usage, right, of the media space in terms of content or in terms of things that are published and in terms of things that are sent to the public, whether through the social media platform or through the organized media. Those people think we have laws that deals with things like sedition. And when we say sedition, that's an organized incitement or rebellion of civil disorder against the state authority by any group of people or by any individual. So this is a sort of an offense that is provided by laws in Nigeria, by, I think, the penal court, not the criminal court, if I'm not mistaken, by the criminal court. This is one of the offenses created by the criminal court to say any act of sedition, that's any organized incitement of any form of civil disobedience or disorder against the state authority, is a crime in Nigeria. Again, there is law in Nigeria that criminalize defamation. For you to defame an individual, and defamation is to maybe send out an item, whether orally or whether in written, that lowers somebody in his person in the estimation of the of members of the society, or things that really touch on the character and personality of a person to the extent that it damages his character and his personality. Now, there is a law that criminalizes such an act. So if you disseminate any information that defame a person, that's a criminal offense, right? Then there is law also that criminalize treasonable felony and felony generally. So there are some sort of people that think, in fact, even the Crime Act deals with some sort of content that are shared on the online platform that are also criminalized. So there are some sort of group of people in Nigeria that think we have more than enough laws that regulate and that deals with things that will have to do with regulation of the media space, particularly the social media. So they think there is no need for us to have another law to regulate that. That's one aspect of their argument. Another aspect of their argument is there is a feeling of distrust, a kind of, because people in occupation of public office or people, the state authorities are to some extent cannot be trusted. There's a feeling that they cannot be trusted with such laws because they will tend to muscle the right of Nigerians to exercise this particular right that is conferred to them by the Constitution to freely speak against any policy or program of government that is perceived to be anti-people or that is perceived to be against the welfare or interest of the people. So there is a feeling that such regulation is an attempt, right, to muscle the right of Nigerians to freely exercise the right conferred on them on the Constitution. That's the second leg of their argument or the concern they have with respect to that. Now, there are those particularly state officials that think there is need indeed to regulate the social media space. And their reason is simple. They feel like there is no way you can have a social media space or a media space, particularly social media, when people cannot be responsible and disciplined. So if you have a social media space that is used by people without responsibility and discipline, ultimately their argument is that will lead to a sort of anarchy in the society. So they feel the necessity to regulate the media space is to ensure that people are responsible and disciplined in their usage of the social media space and the sort of content they share with the public, right? So, and their feeling is because they feel a lot of information that comes from the social media space are content that have some sort of fake news, and most of the people that send or some of this information or they feel that most of the purveyors of fake news and hate speech are using the platform to send out information. So that's really some of their their grievance. Okay, I can see a question. Not clear, because if there is a fear of disruption, then does that validate section 45? Right? That was exactly the decision of the court in the Hadiza Balai against the IGP, of course, because the argument of the state authority, that's police in particular that went to court, that's the commissioner of police of the FCT, is to say, I mean, the argument of the commissioner of police, who is the defendant, because the protesters are the one that went to court, is to say there is a fear that those people in the exercise of their right of freedom of assembly and protest and demonstration, or they will tend to disrupt or they will tend to cause some sort of crisis or anarchy. And the court answered them to say, okay, if there is any fear that there will be such disruption, you have a duty to prevent the disruption as a state authority. And if there is that breach or violation or such disruption, then you should prosecute those violators in a court of law, because the law has provided for punishment for such action, but not because of the fear prevent or deny the citizens exercising their right conferred on them by the Constitution. So this question is, the issue is you cannot use the Constitution to achieve an unconstitutional means, or you cannot use law to achieve an unconstitutional means, because the Constitution guarantees every citizen the right to freedom of assembly and demonstration. So exactly the decision of the Federal High Court in the Hadiza Bala Osman against the Commissioner of Police of the FCT. So I think, Joyce, I will stop here and let me take the questions, because this is an area I will prefer an engaging conversation. Let there be questions so that we can answer them as much as we can.
Fantastic. Thank you, Maria. So questions. Those of us on Facebook and on YouTube, there was a question somewhere up there. Well, it was a statement, but I will let you deal with this. Then I say, so the government cannot deny us the right to protest. That's like a question. But there's a more direct question from Adi Tomiwa. Does the government or state the right to deny the request for police permit to protest? What is the clause about police permit and protest?
Okay, it's still on the Public Order Act, right?
Yeah.
The Public Order Act provides that before a citizen can exercise the right of peaceful demonstration or a peaceful assembly, right, he must obtain what is called a permit, a police permit. And it is the state governor that grant approval in the state where such act of demonstration is to take place. And without the permit, no citizen shall exercise that right guaranteed by Section 39 of the Constitution. Right? Now, invoking that particular provision of the law, the police I think around 2008 attempt to deny some set of people in Nigeria exercising the right conferred on them by the Constitution, stating that they did not comply with the requirement of the Public Order Act to obtain the permit that the approval required. Now, those people went to court to challenge that particular provision, to say it is the Constitution that guaranteed us as citizens the right to peacefully assemble and demonstrate. And the Constitution did not place any form of restriction on us. Therefore, the state authority cannot use that law to deny us the right that is conferred on us by the Constitution. Right? Now, the state authority make a counter argument to say there is a feeling that if people are allowed to exercise those rights without any form of restriction, there may be some sort of disruption or breach of peace and order in the society. The court answered that to say, first of all, the Constitution guaranteed the citizen right to freedom of demonstration or right to freedom of assembly or peaceful assembly. And therefore, you cannot use the Constitution by way of making a law, the Public Order Act, to achieve an unconstitutional means of denying the citizen right guaranteed to them by the Constitution. So that's one. First of all, you cannot use that law to deny the citizen their right. That law was to some extent nullified by the court. Right? That's one. And then secondly, if there is a feeling or there is a fear of disruption or violence, the state authority, that's the police that is mandated with the duty to prevent breach of law and order, has a duty to ensure that such act of violation does not take place. Right? And if indeed it took place or it takes place at the end of the day, they have a duty to ensure that those people who violate that particular law then are brought to book by way of ensuring that they face justice for what they did.
Okay.
Yes.
Thank you. I hope that answers the question to everyone who is watching. And if you're watching the replay, please drop your question in the comment section. And I'm sure one of the three musketeers will be there to respond to you. In the course of the rest of the discussion today, whenever a question comes up, I may just copy and let it show to whoever is speaking, so you might address it while you're discussing. Is that okay? Okay.
That's fine.
Nonso and Sarah, would you like to make any contribution to what has been said so far before we proceed to chapter 5?
Yes, we are still coming to speak a little bit more on the fundamental rights. I don't think we have been able to wrap up.
Oh,
so
fantastic.
We'll have further interventions while speaking on the remaining sections of chapter 4.
Fantastic. Okay, so Sarah will continue to speak on the right to freedom of movement. So Onyeka says, so what I am hearing is the Nigeria police. Okay, let me show it to everybody. What I'm hearing is the Nigeria police cannot deny citizens the freedom to assemble or protest. Is this exactly what Onyeka and the rest of us are hearing?
Yes, they cannot. It is a right guaranteed to us by the Constitution.
Make I hear them now.
Except maybe if Nonso is taking section 14, then Nonso can elaborate on maybe some sort of restriction that may happen. I believe Nonso can treat that. We'll treat that in the course of the conversation.
Do you want to discuss that right now, or Sarah first?
Yeah, well, after Sarah's intervention, then I can now wrap up sections.
After Sarah's intervention, okay.
Yes.
So Onyeka, it is true. That is what you have heard. That's what all of us have heard. But wait first. Nonso will still come and add something to it after Sarah speaks to us on the freedom of movement and the right to acquire, freedom from discrimination, and right to acquire and own immovable property. For us women who at some point we could not purchase property without the guarantor. Anyway, let me know what I don't know. Sarah, please come and speak to us. Everyone, please say thank you to Maria. He has done a fantastic job as always. Nonso, we can't wait to see you. But for now, yay! When you say goodbye to Maria for now and say thank you, say welcome, Sarah. Sarah, please unmute while the rest of us go backstage.
Hello, everyone. Good afternoon, and welcome to today's session. It is again a privilege to be here. I'm just going to start off from where Maria stopped, and we're going to be looking at sections 41 through to sections 44. Right, so sections 41 talks on right to freedom of movement. So this right basically guarantees that irrespective of your community or your ethnic group or whatever religion or whatever, every citizen of Nigeria has the right to move freely throughout the country. If you're from Lagos, because you're a Nigerian, you can live in Ondo State, for instance. So this right inures to every individual and guarantees that you can move. There's no restriction on your movement. Like we already established last week that these rights, even though fundamental, are not absolute. So there are certain instances where they can be derogated, and then it would not necessarily amount to a violation of your rights. For right of movement, for instance, there's a clause here. If you look at sub 2, where that right may be derogated from, and then it also goes back to the point Maria made on circumstances that are reasonably justifiable in a democratic society, and also is going to speak more on that. And one of such instances is to impose restriction on movement on a person who has committed an offense, or there's reasonable suspicion that he may have committed an offense to prevent him from leaving the country, and so that he can be prosecuted accordingly. It also applies to where a person has to be, deployed or deported to another country where he has committed an offense to be tried for that offense. Again, there's also a proviso in that section that says that for that to happen, for there to be a restriction of movement of a Nigerian citizen to be tried in another country, there must be reciprocity of laws, an agreement between Nigeria and that other country, such that if someone in that other country has committed an offense to be tried in Nigeria, the country will permit and allow or restrict the movement of that person to allow them to be tried in Nigeria. I think that is as basic as it is, right to freedom of movement. So there's sections 42, which talks on right to freedom from discrimination. And then this also goes to, guarantee your right as a Nigerian citizen, regardless of your gender, regardless of your community, regardless of your religion or your opinion, to not be discriminated against. Also enough to the fact that a person is not to be discriminated upon based on circumstances of his birth. Right, so section 3 here says, sections 42 sub 3, sorry about that here. So basically, right to freedom of discrimination says a person shall not be discriminated upon because of his sex, his nationality, his state of origin, his community, his opinion, or circumstances of his birth. Everybody has equal rights. That section also says that a person shall not have any sort of advantage as well. Sorry, I want us to look at that section again, and then I hope that we are all looking at our constitution, and that is the way that we would understand and appreciate what we're talking about. I mean, this is not hard science. It's here in the book, and we encourage every one of us to go back, even now that we're studying it, to go back to your constitution, and then you can appreciate this better. So here it says that now the proviso to this freedom from discrimination, that's sections 42 sub 3, says nothing in subsection 1. Remember, subsection 1 says no person shall be discriminated upon because of circumstances of his birth or his ethnicity and all. Here, so it says nothing in subsection 1 shall invalidate any law by reason only that the law imposes restrictions with respect to the appointment of any person to any office under the state, or as a member of the armed forces of the Federation, or a member of the Nigerian police force, or in the service of a body corporate established directly by any law enforced in Nigeria. So these are instances where I mean, for instance, there may be a law that says, I mean, it is just, I think it is normal right now that for you to work in a state parastatal, for instance, you have to come from that state, right? So this doesn't amount to breach of that right to discrimination. And again, I would also want to stress the fact that we had said that a lot of times the question that will most likely come up here is when people put out, I mean, corporate, private organizations put out what they call this now, application, invite for application for certain positions, and then I mean there can be a lot of direct and indirect discrimination. Oh, we don't want women, or we don't want people of a certain age bracket and all. Again, it is also important to stress at this point that while ultimately it is the court that would, you know, give a pronouncement on whether such act amounts to discrimination or not, it's also important to know that every corporate organization has a right, you know, they have rules and regulations, and in, you know, in the administration of their organizations, certain things may not necessarily fall within, will not necessarily amount to a violation of your right against discrimination. I hope I'm making that a bit clear. And the last right I'm going to talk about right now is sections 43. That's the right to acquire and own immovable property in Nigeria. So every Nigerian has a right to own properties. Every Nigerian has a right to own lands. However, subject to the Land Use Act, if you have time to go through the Land Use Act, you will learn that lands, basically all lands in Nigeria, in a state, is vested in the governor, who holds same in trust. However, you can purchase land. And where for any reason, I mean, when also is going to come up, we're going to see that sometimes when we talk about public order, public morality, for public use and all, it may, you know, it may derogate from this right to own property. But if you look at paragraphs A of subsection 1 of section 44, you see that once there's a need to compulsorily acquire a person's land or a person's property, he's entitled to compensation, and he's also entitled to seek adequate redress, you know, to ensure that his right is not violated in that regard. Here, so if you look at subsections 2 of sections 44, there are a list of things that would not affect this right. For instance, where there's a court judgment, you know, attaching your property, and the court has made a pronouncement on it, and your property is taken away from you, it will not amount to a violation of that right. Another instance would be where there are certain payment, taxes and all that, you know, accrue on a land and you don't pay, and it is a decision is reached and that land is taken away from you, or that property is taken away from you, then it will not amount to a violation of your right. If you read through it, there are quite a lot of instances where derogating from that right is not a breach of your right to own property. Right, so I'm going to just go straight to subsection 3 now of that same section 44 that we're looking at here. It says, notwithstanding the foregoing provisions, the entire property in and control of all minerals, mineral oils, and natural gases, and under or any land in Nigeria, under or upon the territorial waters of the exclusive economic zone of Nigeria, shall vest in the government of the Federation. So that is exactly why when you look at the exclusive legislative list, you find things like maritime law, you find things like this exclusive economic zone. Those things, those natural gases and all, is vested in the federal government, such that if you, for instance, buy a land and you discover all those natural resources and all, they automatically revert to the government. Yeah, so Nonso is going to talk on the restriction and derogation of these rights, even though they are fundamental and they accrue to you. There are certain instances where they may be deprived of you, and then it will not amount to a derogation from your rights. Thank you.
Joyce, you need to unmute yourself.
Mm-hmm.
So sorry. So sorry. I didn't realize I was muted. So I don't know if
Yes.
it's just me, if I'm hearing right, or if I'm not understanding correctly. That some laws were created, but then there were other laws in the same constitution made to cancel out. Or I'm not sure. Is that what I'm hearing?
Good understanding of interpreting the Constitution. I don't know if you can hear me. Is one good canon of constitutional interpretation is that the Constitution will not give a right in one provision and take it away by another provision. That is one thing to keep in mind. That is why I would like us to keep in mind the constitutional terminology. Sorry, it will be a little bit some hard law stuff to discuss here. It would be preferable to see these things as restrictions of these rights, derogation from this right, rather than violation. The constitution that created the right will not, in another provision, give people the power to. Violation suggests doing it in bad faith, or what is called
But
malafide.
it will give the right to have it restricted.
It will give some restrictions because we know that absolute, such as in the same vein as absolute power corrupt absolutely. It will be said that absolute right itself could also corrupt absolutely, because if you permit me to use that phrase. The point that is being made here is that if we want to have what some authors have got to enable us to have a more balance of rights. Remember that in the beginning of the conversation, Sarah mentioned that your right to stretch your arm stops where the right to another person to protect his chin from receiving a blow starts. So if there are no such checks within, not even in the international statutes that promulgated this right and in the United Nations Charter of 1948, do we not see some provisions that enable us, for some reasons, to restrict some of them? So whatever it is, but let's leave it as restrictions, so a little bit of derogation other than outright violation.
Yes. Okay, thank you. Everyone, please say thank you to Sarah. Sarah and I will go backstage. Nonso will continue discussing our rights, and after a while, we'll proceed with more. Nonso?
Okay. Thank you very much. And thank you for paying attention so far. We have to wrap up the conversation on Chapter 4 of our Constitution, which guarantees our fundamental rights. And we have two sections left in that chapter. That is sections 45 and 46. Section 45, as the previous speakers have been heralding, provided for derogation of certain rights, so that it is not all the rights that Chapter 45 contemplated in terms of restrictions. In fact, if we look at the discussion we've been having so far, we see that some of these rights, even in the provision itself, gives some what we call provisos, some restrictions within the section. But we can say Section 45 is an attempt to have a more general provision to restrict some of these rights, to enable us have a little bit more balancing of rights of individuals and balancing of individuals' rights and the need for public safety, public order, public morality, and public health. So that is why sections 37, 38, 39, 40, and 41 sort of begins the conversation that there could be need to, in the interests of public defense, public safety, and the other circumstances stated that this right could be derogated from. And we could recall from discussions we're having that the right being referred to here is the right to private and family life, freedom of thoughts, conscience and religion, freedom of expression and the press, right to peaceful assembly and association, and right to freedom of movement. Lest I forget, let me quickly lend a voice to the whole conversation around police permits. And the argument holds, and this is the one I would be happy to subscribe to. It is still argued because that particular provision, that particular law, it still remains the law of our land. But the argument was that that particular Public Order Act has outlived its usefulness. Time and again, it's been seen that even when the Constitution provides for such restriction, the Constitution and the lawmakers in terms of constitution will not allow any second provision that we take from the back door a right that it has accorded. So it is because of this background that one can safely say that the constitutional right to movement and peaceful assembly have not in any way been removed or completely removed by the Public Order Act. Because the provision, remember where we're coming from, the Public Order Act, it's way back an inheritance from the laws that we had before the 1999 Constitution. And the exact wordings of the 1999 Constitution have subjected this derogation to such law that is reasonably justifiable in a democratic society. That is why it is open to the courts to decide, as they've been able to decide in a lot of cases, that the constitutional rights of people to freely assemble in terms of having rallies and protests can be quite sacrosanct and have not in any way been touched or disturbed by the provisions of the Public Order Act. We can see that in a lot of cases that that the courts have held about the meaning and nature of fundamental rights, and of course that celebrated case of Inspector General of Police and the All Nigerian People's Party. So we now continue the conversation. The next subsection of that section 45 talks about an act of the National Assembly that cannot be violated, cannot be invalidated, sorry to say, by the reason of the fact that that it provides for taking during period of emergency measures that derogate from provisions of sections 33 and 35. Okay, that is right to life and then right to liberty. So that we can see in this situation that we say in the state of emergency, the welfare of the people is the supreme law, as the maxim goes. So there is the constitutional allowance or the constitutional derogation that enables National Assembly to be able to make such laws. But one thing that we need to keep in mind is that it is not something that will be taken too far in terms of to expand whatever whims and caprices that suit the lawmakers. The Constitution was elaborate to give some of the to circumscribe or circumspect situations and circumstances within which such rights could be made. Because in subsection 3 of the said section, the Constitution defines what is meant by period of emergency, which is the period which there is in force the proclamation of state of emergency declared by the president, by the powers conferred on the president in section 305, which we shall see in the later part of the conversation. But an interesting thing to put there is that in nowhere in the Constitution is the rights guaranteed in section 36(8) ever restricted or ever derogated from by virtue of constitutional permission. In fact, the opinion holds that this is the only section, this is one of the only section, one of the rights that is absolute And what is Section 36 talking about? It's about where we're coming from during the Ogedengbe, Bartholomew, and the other of their colleague, where by virtue of a decree that was backdated to catch up with when they committed the offense, to be able to enable them to suffer the penalty of that particular decree. That was a very unfortunate development in the annals of our history in Nigeria. That is why the framers of our constitution made it so clear that that nothing except in respect of death resulting from acts of war, or nothing authorizes any derogation for the provisions of Section 36(8). So the summary of the conversation here is that there are restrictions, but these restrictions are to be interpreted or are to be construed in a very limited circumstance, where the circumstances such as defense and public safety, public order, public morality, public health, as we have seen in our COVID-19 situation, have offered. Ordinarily, these rights are not easily violated from. We'll later see in the next section that we all have the further opportunity, because the provisions of Chapter 4 of the Constitution are so comprehensive that the Constitution also envisages that, having guaranteed all these rights, there will be situations where, whether directly or mere suspicion to happen, there will be act of violation of this right. So this Constitution, further in Section 46, gives us opportunity to enforce our rights. And the Constitution allows this provision to any person. If we look at the discussion that we have been seeing so far, we've seen that there are rights that the Constitution begins with every Nigerian citizen. We saw that in such as the right to own immovable property anywhere in Nigeria, which is the right that is accessible to every Nigerian citizen. But look at the wording, if we can go back to the Constitution that Joyce have advised us to download for us to understand better. The provisions of Section 46 of the Constitution is to any person. So really, you don't need to be a Nigerian citizen to seek access to the court to ventilate your grievances and seek redress where your rights have been violated. There are no restrictions. So any person that alleges that either the rights has been violated, is being violated, that means maybe that happened, and you can still come back. There are no limitation provisions. There are no limitation restrictions to when you can bring these rights. Also, it is being violated. You don't need to wait until it concludes. Let you have a conclusive evidence. So that as you speak now, it's being violated. They've served you some papers. They are coming to clamp you down and do this, or it's likely to be violated. This is quite expansive. That you look at this by virtue of the way the whole story is developing and hitting up, fear the rights to be violated. So on any of these circumstances, you have the right to have access to the high courts in any state to come and seek redress for the violation of these rights. And then this is where the professional services of a legal practitioner will be key, not because it's compulsorily so. By virtue of you have a right to you have a full access to ventilate your grievances in the court. The constitutional provision did not say that you must come and exercise this through a legal practitioner, but because of the fact that you want to carefully couch your rights, you want to carefully put them together in documents that will be presentable within the acts of the trade and agreeable for the court to see and hear them, it may pay to seek the services of a legal practitioner that will be able to articulate your facts, put them in a story, which is called statement, and then from that story, extract an affidavit that you will be able to depose to, sort of hearing from you or hearing from any person that has authority to speak on your behalf, as well as further raise from that story certain rights that have been alienated, that have been violated, that is putting them in that originating summons, and then present them with a sort of written submission, arguing with submissions like legal argument, repeating this whole thing what we say, adding a couple of slow cases and presenting them to the courts for the courts to hear. Okay, so the high courts are given the powers, further powers to have original jurisdictions to hear and determine these provisions. So what it means is that you cannot go to the magistrate court, for instance. You have to go to the high courts of the state that is closest to you. And then from time to time, there are rules to the game. Anything we do, we have our rules, even in our homes. So the Chief Justice of Nigeria is empowered with the power to make the rules, to enable, to advise, like I've just explained, the procedure with which these enforcement provisions can come to the courts. And the Chief Justice of Nigeria so far have been up and doing in that. They've gone ahead to make rules. We should have up to the Fundamental Rights Enforcement Procedure Rules of 2009, which legal practitioner will also use to enable you to have good access to the courts. Okay, now the other thing that will come up in mind here is that, well, who can really exercise this, if there are such rights that are cultural in nature, or such rights that are social in nature, whether a non-governmental organization, for instance, have the opportunity to come and ventilate this right on behalf of a larger group of people. AFEM had opportunity of making this submission at the highest court of the land, the Supreme Court, and the response of the Supreme Court to our argument was in the affirmative. Yes, that the locus, or what is called the opportunity to present such cases, also accrue to non-governmental organizations. They accrue to them because the courts have always had the frame of mind, the disposition to rather expand these rights instead of limiting them. In fact, the courts are very much encouraged to think in favor of this right. Now, what then happens to a situation whereby a certain act was carried out by another individual that hurts you, but in course of carrying out that act, that affects you, but in course of carrying out that act, a fundamental right was breached. Well, the courts have been able to maintain that the nature of our fundamental rights are quite sacrosanct, that there is no act that can be seen to have been done that breaches your fundamental rights that we see to be valid. For the mere fact that such act breaches your fundamental rights, such acts, if you seek redress before the court, will be violated. And in recent times, this principle have been extended to even relationship between citizens, employer and employee. For instance, people have been able to come to the National Industrial Court to commence action via fundamental human rights that were violated by their employer. And for that reason, the courts have come up to hold that a termination that occurred as a result of a fundamental right that was violated, that termination was deemed to be invalid, and the courts have gone ahead to award huge quantum of monetary damages in such circumstances. So the breach of provisions of fundamental rights provision renders any act subsequent to the breach a nullity. So it's a complete nullity, and the courts have continued to uphold that right. So the summary of the discussion on this section 46 is the access to the courts. Yet again, this is the second time we'll be highlighting access to the courts. We saw that in our first conversation in part 1 of section 6. We are seeing that yet again in chapter 2. in chapter 4, which is in particular reference to fundamental rights. So you have that access to court, and this access to court is available to you if you feel that your rights has been breached, is being breached, or is likely to be contravened. And of course, remember that you have to have this access to the High Court of the state. And so, in the absence of any question, this will be a good place to wrap up the conversation on chapter 4 of our Constitution, which, in the one hand, enables some restrictions and derogation from the fundamental rights. And I'm saying this is just to enable us to coexist more peacefully and balance our rights, and also enables us in the next and last section 46 to have access to the court whenever we feel that our rights are being violated, or that our rights are likely to be violated. And of course, I'd advise that it will be wise to seek the services of a legal practitioner in order to assist in articulating this whatever grievances you have well, and so that it will be a little bit presentable. You are not short at if you don't present them well, but I think it will make a whole lot of sense if your coherence of presenting your story before the court, it will make a lot of sense for the court to also understand, and for the court to be able to give you opportunity to ventilate your grievances. Thank you very much.
Thank you very much, Nonso. So my question is about access to legal representation. Is there a provision somewhere for free to very affordable representation? Because we know that legal fees are not cheap, and if you need representation and you can't afford it, at whose mercy are you?
Yes, the state hasn't abandoned persons who, in such situation, are not able to afford certain legal practitioners. First of all, by the instrument of the state, there's the Human Rights Commission that even gives you opportunity to come and air your grievances, and they have the opportunity to assist in seeing how you can ventilate them. There's also the Legal Aid Council. There's the Legal Aid that enables indigent citizens who are not able to afford legal services to have legal practitioners provided to them by the state, paid by the state to give them access to legal practitioners. And as is the
where do we find them?
Oh, they are available. They are available. The National Rights Commission is headquarters in Abuja and has branch offices, nodal offices in almost all the states of the federation. The same thing with the Legal Aid Council. They exist in various state capitals of the federation, and even the NYSC has a particular group of community development that are key. That their key focus is on legal aid, having access to people. And the last point I want to make is that law firms in their corporate social responsibility are also doing a lot of good in this direction. I will speak from the point of view of Primaria Africa Legal, that has quite a number, if not more than 50% of cases that we do to assist in this in this sector. The disposition of our principal partner, Boma Yomida Labi, has been, well, there is no need for people to wait for so long without knowing, without having their day in court. It's not a guarantee that what the judgment will be, which we will not do, but it's to say, well, you don't need to wait too long. Let us give access to enable you have your day in court, and then enable the court to decide one way or the other. And I know there are also a number of law firms that are also keying into this corporate social responsibility, into the kind gesture. So there are means out there. So once any person who feels that's right has violated is able to cry out maybe to Joyce, for instance. Joyce will have an opportunity to assess a lot of people, given the opportunity that he has with this platform to make references. And I think any reference that comes from Joyce will be treated very seriously.
Thank you very much. Nana is asking, is the Legal Aid Council effective? I'll allow Sarah answer this and then proceed with the next chapter, which is on the legislature. And how do they ensure non-interference from the government that put them there to offer legal aid? So while Sarah is about to respond to this, the rest of us will go backstage. Everyone, please say thank you to Nonso in the chat. This is very enlightening for all of us. It's not enjoyable, really. It's not this is not exciting, but we need to know. And one of the reasons why we've not known is because it's not been exciting. But now we are seeing that if we're going to make progress as a nation, we must get to know the non-exciting part of the law that everything else is based on. So please say thank you to Nonso. These beautiful people are trying to make it easy and understandable to all of us. In a short while, we'll see people deliver these lectures in local dialect and pidgin. So Sarah, over to you. The rest of us are heading backstage.
Okay, so straight to answer the question, is the Legal Aid Council effective? I believe it is. From my interaction with the council itself, first as a youth corps member rather, and now in practice, I know that they are effective. They take up cases for indigent people, and then on how they can, prevent non-interference. I mean, they can do their best. You know the kind of country that we're in. I know, but if people stay focused on the object of the council, for instance, and then stay true to it, they will continue to do more, even more than what they're currently doing. So yes, they are effective, and they have their own acts. If there are cases of interference, they can equally take it up. I mean, we have the courts for interpretation of whether because the executive or any arm of government sets it up, then there should be interference. I mean, we have separation of powers and all, and then they are very effective. So I think I would answer that question in that way. I hope that I have effectively answered it. Right, so I would just go on to Chapter 5 of the Constitution. It is quite bulky, and then I'm also going to thank Maria for doing justice to it. I think the first session that we had. So as a way of recap, more like a way of recap, and we'll just and then for want of time, we will try and rush through it. Right, and well, just to add again to the how effective Legal Aid Council is, these are legal practitioners, and then we have integrity of the bar and even individual integrity to protect, and it is one thing that is commendable there as well. Right, so we're going to go into Chapter 5 of the Constitution. Like I said earlier, it is quite bulky, and for want of time, we will just breeze through it. And then, well, of course, covering as much as possible today. So the National Assembly, that is the legislature, is the arm of government that is responsible for lawmaking. We have established, and as we will see in the course of today's session, that we have three arms of government: the legislature, the executive, and the judiciary. We're going to be speaking on legislature. This is the arm that is responsible for law making, and we have established earlier that Nigeria operates a bicameral system. That means that we have two houses, and then we have the two houses together comprises or makes up the National Assembly. We have the Senate and we have the House of Representatives, and they make laws together to right. So it's already provided in the Constitution, Section 47 there. And the Senate here, The Senate composition of the Senate, it is made up of 3 senators from each state. We have, I think, 108 senators, 1 from the Federal Capital Territory. That is 109 in total. Also, the House of Representatives also consists of 360 members representing constituencies of each state. The House of the Senate, for instance, is headed by the president. We have the president and we have the deputy president of the Senate. And for the House of Assembly, it is the House of Reps, House of Reps by the Speaker and the Deputy Speaker, House of Representatives. And these heads, presidents, speakers, they are elected by members of the House. Right, so we're going to look at qualification to become I'm looking at sections 50 sub 2 now. It says that the president or deputy president of the Senate or speaker of the or deputy speaker of the House of Representatives shall vacate office if he ceases to be a member of the Senate or of the House of Representatives, as the case may be, by virtue of dissolution of that house, or he is removed from office by a resolution of the Senate, or when the house of which he was a member first sits after dissolution of that house. So these are instances where you can vacate your office as a senator. And then the Senate has, the National Assembly has a clerk. There's a clerk of the National Assembly. So we have, the next thing we're going to look at is to become a member of the National Assembly. The law says that you must declare your assets and your liabilities, and then you must take the oath of allegiance to the country to show that you are for the country and not against it. Right. Section 55 here says presiding at sittings of the National Assembly and joint sitting. So sittings in the House of the National Assembly is presided over by the president. In his absence, the deputy president, this is for the House of for the Senate now, or the speaker or the deputy speaker in the absence of the speaker for the House of Representatives. The quorum of the Senate or of the House of Representatives shall be 1/3, that is, of the total number of people that are supposed to be present in the Senate. If there are at least 1/3 of the members, then they will be, it will be proper for them to sit. So quorum is like, when we say quorum, it is like the number of persons who must be present for a meeting to be held, properly held, right? So if there are at least 1/3 of all or 1/3 of all members of the legislative houses concerned, then a quorum would have been formed, and the House can properly sit and deliberate on issues. The Senate is to conduct, the National Assembly is to conduct its proceedings in English or in Yoruba or in Hausa. However, adequate preparations for that would be put in place. Okay, so here we have any person. Okay, we're going to take voting. So right, voting into the people to assume the office of, getting into the National Assembly is by voting, like we already know, and they contest via a political party, and then vote are cast, and the winner is elected, and then they get into the House and are elected as such. Now we're going to talk about mode of exercising right. I mean, it is also important to know that to be a member, to be qualified to contest election as a member of the House of either of the Senate of the National Assembly, you must be a Nigerian. You must have, I think, a school cert, you must be a person of sound mind, and then you must for Senate 35 years, for House of Reps 30 years. So all the eligible candidates that we have, all the youths that are fighting for a better Nigeria, this is the time to come up and contest, because you are very eligible. You're a Nigerian, you have I think a minimum degree of school cert or so, and then you are 35 years for Senate, 30 for House of Reps. Generally, how laws are made in Nigeria, we have said that we operate a bicameral system. The Senate and the House of Reps, they make laws in such a way that a bill, for instance, may originate from the House of Representatives. Deliberations are had on that bill, and then it is transmitted to the Senate, for instance. The Senate would also deliberate on it, and if the requisite vote is cast in favor of that bill, then it would get to the president, who would give his assent to the bill. Maria already stressed I think during our first session, that a bill does not become a law until it has an assent of the president. However, there are certain instances where the president does not, where that assent can bypass. So sorry, there's a question here. It says, if you break your oath of allegiance, who determines this and what is the penalty? So your oath of allegiance, for instance, and one of the times when a person can be disqualified or removed from the office of either the Senate or the House of Assembly, is where you voluntarily take the citizenship of another country, right? Or in times of war, for instance, you make it clear that you are not for Nigeria, or you are putting yourself in a position where you are divulging sensitive information about the country. This is quite clear. When you break your oath of allegiance is such that you are dedicated to Nigeria and to the cause of Nigeria, to the development of Nigeria. And when you do anything at all that goes contrary to that oath, it would be said that you've broken the oath. And then ultimately, who determines this and what is the penalty? The penalty, for instance, is that you'll be removed. And this, I believe that probably Muawiyah would speak on this, but I believe that the House, I think that there are certain instances where they set up committees in the House, and they will sit on certain specific matters, and a committee may be set up, for instance, to determine that, or ultimately the court would make a pronouncement on that. I hope I've been able to answer that question. Again, it could be a ground for recall. It's happening now. We're seeing it as a result of this NSAS protest. A member of the House of Reps in one constituency is being recalled, and that is something that can happen. I'm going to be as fast as possible. Okay, so we're going to look at sorry. Yes, okay, so I think I've talked about disqualification of members of the House, and here I said where you voluntarily acquire citizenship of another country, where you have been sentenced to death, or where you have been sentenced to death, or within the period within 10 years before you contest for that election, you have been convicted of a criminal offense, or you have contravened any provisions of the Code of Conduct, or somebody who is an undischarged bankrupt, for instance, cannot contest. And then the law on that is that an undischarged bankrupt must be so pronounced on by the court. The court must have heard your matter, and pronounced you to be such. And a person who is employed in the public service, for instance, cannot contest as a member of the National Assembly, either of the Senate or of the Reps, except you resign from that position, or you're a member of the secret society. If you look at the interpretation section of the Constitution, secret society is defined or is explained. I mean, there are certain associations that use signs or in the process of initiation engage in inhuman activities and all, or such activities that sort of want to foster the interest of their members to the detriment of others. I mean, those are, if you look at that interpretation section, it is clearly defined as such. So, sorry, please. How do they come up with bills for deliberations? Can anyone just come up with anything for deliberations, or are there guidelines they follow to come up with a bill? So when we discussed chapter 2 of the Constitution, we talked about I think fundamental objective and directive principles, and I think around state policy, and also in Nigeria, for instance, has that chapter 2 in force, which sort of like gives guide to activities in the country and how state policies and all should be carried on. For instance, when a matter becomes a national issue, for instance, I think anybody can come up with anything. I don't think that there is a particular. You look at you're representing a particular constituency, you are representing a people, you see a need for there to be a law, for the betterment of the people, you bring it up. Except any of my colleagues would speak more on it, but I believe that this is it. You're here to represent people, and the chapter 2 of the Constitution is already there to guide you. You see that there is a need to address certain things, like when there was a need to address to modify or to amend the Companies and Allied Matters Act, for instance. I mean, there are certain issues that have been recurring, and then it became very obvious that there had to be an amendment of that act, and we had it. I don't know if I've answered that question correctly. I don't know if Yes, Nonso spoke about this extensively when he talked about citizenship. Nonso spoke about this when he talked about citizenship. So, there are certain instances where dual citizenship may not allow you to. I think Nonso should come back to this question, please. Joyce, if you can bring Nonso on, thank you.
Thank you very much, Sarah. Thank you very much, Joyce, for bringing me back. Okay, so Sarah rightly said that, how do you come into this arm of government? You must be a Nigerian citizen. And if you want to ask whether someone with dual citizenship, can come into this arm of government, dual citizenship, if one of the citizenship is by birth, okay, if one is by birth, it's only the citizen by birth that can preclude you by birth to Nigeria. You must have acquired Nigerian citizenship by birth. That is the only exception with which you can go ahead and have this offices, and nothing can derogate from it. We brought up the case of Saraki, for instance, that because he had his Nigerian citizenship by birth, the very fact that he has another citizenship did not stop him from becoming a member of the National Assembly or becoming the Senate President of Nigeria by extension. But if your citizenship is not by birth, imagine that you acquire citizenship by registration because you are married to a Nigerian and you come to register, you acquire citizenship by naturalization because you've spent some years in Nigeria and the government you have applied and the government find you worthy to grant citizenship. It comes with its own limitations. If you go ahead and acquire another citizenship, another citizenship of another country, you will not be eligible to continue to enjoy your Nigerian citizenship. To that extent, you will not be eligible to be elected into this position that Sarah is discussing about. So that is the simple explanation to that. If it's dual citizenship that you have the first by birth, you can proceed to the elective position. But if you're not a Nigerian citizen by birth and you go ahead and acquire another citizenship, you don't have that right to contest for the elective position. Thank you. You can proceed now, Sarah.
Thank you so much, Nonso. So I'm just going to go straight to.
They are not ready to let me leave. Okay. My parents are Nigerian. I'm born in Ghana and I have Canadian citizenship. You are a Nigerian citizen by birth, by virtue of the fact that your parents are Nigerian. And the previous question that I saw before this one, I wish I can go back to it. Okay, what if you acquire citizenship through your parents who are born in Nigeria? Of course, that is one of the ways of acquiring citizenship by birth. If you are born in Nigeria, if your parents, because the first level of citizenship for us is by descent. That is, your parents or grandparents were born of any community that belonged to the territory of Nigeria before independence, or your parents or grandparents were Nigerian after independence, the date of independence. Then if you are born outside Nigeria to a Nigerian parent, but not extending it to grandparents, you're also a Nigerian citizen by birth. And by so doing, you can contest for any elective seat. Any other further comments, you'll be able to have opportunity to put them together and respond to them in the comment section.
All right, thank you so much, Nonso. So I had mentioned recall, where a member of the National Assembly can be recalled by their constituency, and I also said it is happening currently. And how do you go about this? If you look at the provisions of Section 69, paragraphs A and B, it says that you must present a petition. A petition is presented to INEC, and it is signed by at least 1/2 of persons who are eligible to vote in that constituency. And there's an election, I think a referendum, sort of, also by people who are eligible to vote in that constituency. And once that is done, that the INEC is mandated to conduct an election to fill that vacancy, and that is the procedure for recall of members of the National Assembly. So for want of time, I'll also just breeze through the same, and then let me also just state here that all I've been discussing right now is as relates to the federation. We say for the federal level, we have the National Assembly. For the state level, we have the House of Assembly of each state. And the same, more or less the same provision applies in the House of Assembly. The House of Assembly is established in the Constitution, House of Assembly of each state. It is also it also comprises of the Speaker and the Deputy, right? If I'm correct, right? The Speaker and the Deputy, and it is made up of representatives of each constituency as well. Here, I think we have about 36, right, or 40 members. So here, provided that a House of Assembly of a state shall consist of not less than 24 and not more than 40 members. Also, to be elected into the House of Assembly, you must declare your assets as provided in sections 94 of the Constitution. The House of Assembly is presided, sittings at the House of Assembly is presided over by the Speaker, or in his absence, his deputy. Also, the quorum is by 1/3 of all members of the House. Proceedings are proceedings at, oh, sorry about that. Okay, so to be eligible to contest for the House of Assembly is here provided in sections 106 of the Constitution. You must be a citizen of Nigeria. You must have attained the age of 30. You must have a school cert qualification, and you must be a member of a political party. The same applies to the National Assembly. You must be a member of a political party and be sponsored by that political party, and then you'll be eligible to contest. People who are disqualified, also the same thing for National Assembly. If you're not a Nigerian citizen, or you have voluntarily acquired the citizenship of another country, as Nonso has already rightly mentioned, you are a person of unsound mind, you have been sentenced or you have been convicted of a criminal offense, I think, or you're an undischarged bankrupt and all. And yes, deliberations at the National Assembly, at the Houses of Assembly, is also done via voting, and the governor in this case would also assent to the bill, and it becomes a law. If I have missed out anything, I'm already below schedule. Maria will speak to it.
Please join me say thank you to Sarah for dissecting these parts of our fundamental rights. Thank you. The truth is, the questions will continue. After next week Sunday, which is the 15th of November, on the 22nd Sunday, we will have an open house. That day will be all about questions from every part of the Constitution. Look, we would have a full house with about 2 or 3 lawyers, and we would have 2 hours of dealing with our questions. If by any chance your question is not dealt with, it's okay to still put it right there in the comment section, and then we will call it up. There's a question I saw on Facebook. For some reason, the Facebook questions are not showing here. So one question there said, does the government have the right to arrest protesters after the protests like we had? Of course, everything is still about NSAS, right? What rights protesters have in the Constitution? What about the people who we are hearing accounts are being frozen? We don't really know who they are. Personally, I haven't heard anybody say, hey, my account was frozen. We've heard stories. I'm not sure that anyone has been corroborated per se, but please tell us about the rights here. Sarah and Maria, before you disappeared. Also is smiling in the background, so please let me bring him up too, just in case. All right, let's hear.
Okay, maybe Joyce, if I can get the first question again. I missed the first question. There was a sort of glitch here.
Okay, the question is, does the government have the right to arrest protesters after a peaceful protest like the one done for NSAS? And let me quickly add to that, does the government also have the right, or CBN have the right to freeze accounts of people who receive donations from friends and family to support the peaceful protest? This is from Gloria Odumo. Maria?
I think I missed the question again. I only got the part whether CBN can froze the account of protester. Was that the question? or account of people? Was that the question?
Yes, that's part two. Part one is, can the government arrest protesters?
Right.
After the
Okay.
protest.
This is similar basically to the question we answered last week. Unless there is any breach of law and order, unless there is any violation of law, unless there is anything that is done that is wrong in terms of an offense, no authority has the power to arrest a person just because he has exercised his right to peacefully demonstrate and exercise the right guaranteed to him by the Constitution. So if you demonstrate, if you exercise your right to peaceful assembly without any form of violation or disruption, or without any form of crime being committed, nobody should arrest you, and no authority has the power to arrest you for that. However, if in the course of exercising that right of peaceful demonstration or peaceful assembly, you commit an offense, or an act is committed that the law perceive it to be an act of offense, or to be an offense, for that particular offense, you can be arrested and you can be investigated. And if you are found to have violated any law, you will be tried in a court of law, and the court will give its sentencing and its own decision on that. So, but for just exercising the right of protest, no, the authority cannot arrest you.
What about the freezing of the account?
Yes, I will go to the issue of freezing of the account. Different laws regulate issues of freezing of account of a citizen. Now, up to this moment, I, as a person, have not gone to any of the court, or the court where this order was obtained, to see what was the detailed application that was made to the court. What was presented to the court for the court to give such an order. Now, there is the EFCC Act, there is the ICPC Act. All those laws have given powers on the authorities to apply to the court to freeze account of a citizen on account of suspicion of crime, or on account of allegation of criminal activities being committed through the account of the citizen, right? There is the Anti-Terrorism Act that also has to do with financing of terrorism act, that also provide, or that also empower the state to freeze account of suspected individuals who are suspected to have committed an offense under that law. Now, for us as of today, with respect to the law list of the people we saw on social media and the order we saw obtained from the court, we have to wait and see what was the details that were presented to the court to seek for that order, and under what law was that particular order sought, and under what law was it granted, before we can be able to say whether this is really justifiable or it is not justifiable. So as of now, we have to wait and obtain those information before you can make such conclusions.
Okay.
On my part, I will speak in favor of due process. I will speak in favor of due process, and I am minded to speak on this due process because they went to the court to seek this order, and the court had them and granted this order. We have to give presumption, maybe when we now discuss chapter 7 on judiciary and judicature, that the people we appoint to the court are reasonable people that will not just come and take any facts that people give to them and give orders without basis. I would have had an issue with freezing if they did it without an order of court. But I'm not speaking this from the point of view of the sector where I belong. For the mere fact that there was opportunity to go to the court, make a case before the court, a court had the necessary, what we could call discretionary facts and material facts to give this order, I would like to presume in favor of the due process that was followed in obtaining the order. And I also agree with Maria that until we now see the content of those papers that the president before the court to warrant the giving of the order, it may be premature to comment whether they are correct, sought and made. But let us presume in favor of due process that was followed.
Okay, you know, it's very touchy. Many of us are overwhelmed by the sheer, for lack of a better word, insolence I'm civilian here, non-lawyer,
Yes.
non-partisan concerned Nigerian, where young Nigerians, young and old, in fact, it has nothing to do with age, where Nigerians were out there protesting, asking for something, and the things that were the 5 items asked for, we really haven't seen anything. Okay, we hear that some states have arranged what do you call them, judicial panels to sit. We've heard that the names of the SARS police officers, names that have been on the list forever. We're hearing all sorts of things. Some days I'm just like tired, like, oh my gosh, can I just go to Canada? Even though I really don't want to go to Canada, I want to stay here. So
We must
right now we're all
ourselves,
very,
nobody else.
this is home. This is home. Even if we go anywhere, we are going to have to come back at some time. So we're all touchy. It's 7 minutes to the end of our discussion for today. I'm wondering if we should go ahead and start chapter 7, which is the executive, or we can just take 1 or 2 more questions, call it a day. Next week, we hit 7 and 8. What do you guys think?
Yeah.
I would honestly go with taking questions because they are very
You mean
elaborate
chapter
chapters.
6?
And if we start, we cannot go any, we cannot even take anything. So it's better we take the question.
Okay.
I agree.
Okay. So NSS is coming back. Well, Nene, please, we need you. We need you here in Nigeria. Everyone on YouTube and on Facebook, should you have a question, this is the time to post it so that we can deal with it. Or if you think your old question, your past question wasn't well dealt with, we would just give about 30 seconds to see what questions come up. If there are none, we would see thank you, and we would have a good evening and
There
a
was
great
a
week.
question when Sarah was presenting on whether citizens can present bill and the lawmaking process of the National Assembly.
Yes, please. Yes, please talk to
Let
us
me just
about that.
mention that the National Assembly as an institution had some sort of laws or regulation that govern its affairs, separate from the Constitution and any other law. And it is called the National Assembly Rules. So their rules dictate how a bill should be presented in terms of proposal for lawmaking. Now, it is the lawmakers, that our representatives, first that present any form of a proposal to be a law in Nigeria. And there are certain criteria and procedures that are listed in that particular rules for a legislator to present a bill or to present a proposal for lawmaking. And then even the executive, there is what is called the executive bill, can present a proposal or can present a bill to the National Assembly for it to be made a law. And there are processes and procedures that are listed under the law for that particular proposal, for any particular proposal for the National Assembly, from the executive to come to the National Assembly and be passed as a law. So we have a couple of them. I think as of today, we have the water resources bill that was proposed by the executive that has already been generating some sort of issues around. And then some couple of other proposals, even the petroleum downstream IB bill that is before the National Assembly was proposed by the executive. So it's a process, and there are certain criteria that are listed in that rule before you can be able to present a proposal for it to be passed into law in the National Assembly.
Fantastic, thank you. There's a question here that says, from Onyeka, does the Senate or the House of Reps hold plenary sessions open to the public? I have the answer. The answer is yes. If yes, how can citizens participate in such? I know I've attended a few in state houses of assembly, but I've never attended any at the National Assembly. So do you know how we can, do we just go on the day that there is plenary? How do we even know what days they have plenary?
I'm really interested in this question. And I think that's something as citizens, maybe I will allow the other members to comment, but I think as citizens, we are taking our rights and our powers for granted. Let me tell you, before any law becomes a law in Nigeria, you and I and every Nigerian have a say before that law is passed. There is what is called the public hearing before any law is passed in Nigeria. And I think as citizens, we have really undermined ourselves, and we have really not taken advantage of that power that is given to us by the Constitution. You really see citizens take it serious and personal when there is a public hearing. You only see some NGOs and some few organizations going there. Every Nigerian should take interest. When they say there is a proposal that is being presented to the National Assembly for it to become a law, and it is being put to you as a Nigerian for public debate, we should take opportunity of it. We should be able to scrutinize and see whether this bill is what being made a law in Nigeria, and whether if this law is passed, we are safe as citizens, or that law cannot contravene or violate any of our rights or curtail it. So that's a very important instrument that we should take serious as citizens. I emphasize that.
Thank you. Sarah, Nonso, please, contributions to this. How do we know when there's a plenary? How do we show up? Are we going to be harassed at the gate? Do we need to arrive with our national line, BVN, proof of ownership of Nigerian's birth certificate?
As it is with any establishment, I mean,
oh, Sarah, sorry, you were muted, so we couldn't hear you. Let Nonso finish and then we'll continue. Please, Nonso.
Okay. Please, am I audible?
You are.
Am I audible? Okay. Yes. As it is with any establishment, okay. I mean, nothing is really absolute. It's a public place, good and fine, but it's important that, how will I put it, for want of a better word, I don't want to use terminologies that will sound restrictive. You want to let the clerk of the National Assembly, for instance, or you know that because for public hearings, for instance, I know that they do announce, even on national dailies, on the national televisions, and so that okay, there will be also day of public hearing. The general public is invited. So, and when that invite comes, it's important that, of course, you come on the day you are invited. Don't come on the day that they are trying to have an executive session.
Please, hold on. You are saying that we can only attend plenary the days we're invited. How do we know these days?
No. I'm not saying that you can only come the day you are invited. I'm saying you have access to the hearing, but you want to let the administration know that you are coming. I think you want to inform, for instance, the office of the clerk of the National Assembly that you're coming. If you're coming as a group, inform that you're coming as a group, because the point, and I'm not by this restricting the access to go to the National Assembly, but even if you come, there are also some decorums of the facilities of the premises that you also have to obey and respect.
Okay.
That gives you the opportunity.
Are we also saying somehow that they might also turn our what's the word, our notice down? If I say, okay, myself and so and so group were coming, who would like to come to the plenary, do they have the right to say, oh, you're not able to join us today, we're full?
No, it's the hearings, except for an executive sessions that they want to have a closed door section. But for their public hearing, you have your access to come. But I'm saying, okay, do yourself good due diligence of trying to inform and then trying to make sure. Imagine they have some regulations or guidelines of COVID-19. You don't want to come when you don't have that preparation, so that you have a seamless entry.
Okay, I have two questions here that we'll take before we shut down. This one says, is it possible for an electoral reform to be carried out before 2023 to enable diasporans vote? I see Maria's eyes. Sarah, please unmute yourself and let's know your thoughts. And Maria, those your open eyes. You'll also tell us what you think.
Is it possible? Yes, I think that it is possible. The issue will be, do we have people who would champion this? The people who are already there, do we have a government that is progressive enough to want to take this on and get it done with before 2023? But whether it is possible, I believe yes.
The answer is yes. Thank you. Maria, please explain this.
Okay. I think Sarah have answered it. Yes, it's possible.
Okay.
The question is there the zeal? Is there really the willingness and to take it? That's the question that we need to ask ourselves, and that's where we need to emphasize on.
Nene, this has cut our work out for us, that if we want to make this happen, we are going to find out how to get it done. So maybe maybe we should take a note that we'll start here. We'll start on this note next week by answering the question: how can we chase the reform of the Electoral Act? Or perhaps we leave it to the 22nd after we've dealt with chapters 7 and on that open house day when we have questions and we can deal with this. Which one would we prefer? Next week or next week?
Open house day will make quite a lot of good one, so that we are able to have full grasp of the constitution. We'll have an open house to address.
Fantastic.
Let's have the. You never can know whether somebody will comment on it. Other chapters that we have.
Exactly.
And by the way, it's chapter 6 that we're starting from, not 7. We're starting from chapter 6.
Oh yes, chapter 6 actually. Chapter 6, 7, and 8. So we still have some work to do. Thank you. But then also I have this question: does this mean civil disobedience is unconstitutional, as this is the only effective means of protest? And when we say effective, we mean this is the means of protest that ends up being shot at. Nonso?
Yes. Well, I would like us to stay with what the Constitution has accommodated, or what the Constitution has allowed us to do. Constitution, as we have seen in today's discussion, have allowed us to right of freedom of assembly and freedom of movement. If I were to advise any group of persons, I'll prefer them to stick to the fact that they are seeking to exercise their constitutional right to freedom of movement and assembly, than they are going out trying to have civil disobedience. Yes. In nature, whatever they are doing, people that had the stand-up at the Lekki toll gate, of course, there was a lot of obstruction to the vehicular movement, which pain was felt by quite a number of citizens. So a lot of other citizens' rights to movement or rights to movement to their places of work were violated. But I would be happy for them to insist that we were exercising our rights to freedom of movement and freedom of association, than we want to come out ready to have civil disobedience. The mere coloration of disobedience is smack off an act against states.
I don't know if this response is satisfactory, but we will take it. This question is: who is responsible for to check the lapses in the justice system as a whole? I know he wrote there criminal, but I will take it beyond criminal. Just the justice system. How do we check gaps and lapses?
I'm quick to say all of us. I'm quick to say all of us.
All of us.
Okay.
We all have the duty. Remember where we're coming from, because the Constitution have the way of checking all these things. And the Constitution is our Constitution. So the Constitution is there to help us to check.
On
If
the
you now feel that,
22nd.
okay. If you now feel that, for instance, Section 36 that provides for a right of fair hearing is being violated, what do? You come and take out a summons on fundamental rights, which will enable you to ventilate your grievances and enable the courts to interpret and see how.
So you would ventilate your opinions to the court, and you might have to serve the Chief Justice of the Federation, who will also take instructions from the executive, who is not happy with the fact that you.
No, not necessarily. The judge, I'm minded to say the judge will take instruction from you and I, and because they won't see you and I to speak to, them, taking instruction from the Constitution that we have given to ourselves.
Okay.
Yes.
Fantastic. So we'll pack some of these questions to the day of the open house, because I have a number of questions, and I know that these band of people in the comment section who are very interested in the growth of this country, Nigeria, will be here on that day, God sparing life and giving us grace, and we'll ask some of these questions and deal with them. So the responsibility of checking the justice system is on the people, you and I. Let me see if there's one question I might have missed. Somebody asked about the referendum. Says, this is the last question we'll take, please. It's 4:06. This is 6 minutes beyond our scheduled time. We must respect time. It says, what is referendum in this context? Right now, I am not sure what we were discussing when this question came up, but Please tell us what is a referendum? Did you hear me? Can you hear me? Referendum, the question there. What
Okay, I can see a question. I can see a question on that. A referendum. It depends on the context in which you want to take it. It can be a form of a process where a people in a particular nation take a process of a self-determination. When you say self-determination, for them to be an independent entity from the totality of a particular nation. And also it can be a process by which people together agree to select a particular person to lead them. Maybe we can say in the process of electing a president of a country, it can be done by way of a referendum. However, let me be quick to point out that in Nigeria, we don't have anything in the constitution that allow a referendum in terms of a self-determination or in terms of electing a person to lead a particular people. There is a different process for achieving things, but for referendum, it is not provided for.
Fantastic. So, open session comes up 22nd of November, Sunday 22nd, after next Sunday. Next Sunday is 15th November. Then on Sunday 22nd, that day will be the open session. I would, by the grace of God, invite another senior constitutional lawyer. I would invite one of the young man who teaches and has been teaching the Constitution for many years. He was supposed to come join us, but by the time I got his response, Premier Africa had already accepted to partner with us. So I told him to wait till the open house. If by any chance we're not able to deal enough with questions on the 22nd, there's also Sunday the 29th, and we will continue with open house, but we'll be done with the Constitution this November. In December, we will probably talk more about elections and the Electoral Act and what to do and X, Y, Z and more. But well, let's deal with the Constitution first. We'd like to say thank you to Nonso, to Maria, Sarah's, maybe her network went off. We lost her for a moment. If she comes back before we shut down, we'd also say thank you to her. I'd like to say special thanks to all those who are on Facebook and on YouTube and those who are watching the replay. It means a lot to us. Look, no number is too small. The few of us or the number of us who are learning consistently, the truth is there's so much we can do with the knowledge that we have. So share the video. Share the videos. If you just go to my YouTube channel, click on the last 2, 3, share with people, discuss them in your groups, discuss them in your families, discuss them with your friends. Do well to talk about what we have discussed here in your WhatsApp groups, in your family groups, in your alumni groups. The knowledge needs to get around. Host your own shows. If you reach out to the gentlemen and women from Premier Africa, I'm quite sure they would oblige. So please reach out. You want to host your own talks on the Constitution, please seek help and let's all put our hands together to get this done. I want to say thank you once again for being here. Have a wonderful, wonderful rest of the evening, rest of the week. God bless us all. We'll see you next Sunday by 2 p.m. That's chapter 4. That's part 4, and we'll discuss chapter 6, 7, and 8. Thank you. Everybody come off mute and say good night.
Good
night.
Bye.
Bye. Bye.